The next choice is a partnership. A sole proprietor is an idiot. A partnership is two or more idiots working together. Now, partnership is an association of two or more people to carry on as co-owners of a business for profit. Now, you can form a partnership in several different ways, either expressly or intentionally or by accident. You can form a partnership by entering into a partnership agreement. That agreement can be oral or it can be written. You can draft articles of partnership. And again, this is when people know they're entering into a partnership. The third way that you can get into partnership is what they call partnership by implication, or partnership by estoppel. And that happens when people lead other people to believe that someone is their partner. For example, referring to somebody as your partner in a partnership could be enough to create a partnership by implication or by estoppel. Now, partnerships carry the same liability risks that sole proprietorships do, except when you're a sole proprietor, you're only liable for your own contracts and your own negligence. But as a partner in a partnership, you are liable for any contracts that your partners enter into, as well as any negligence, any lawsuits that they get sued for. For instance, a lot of big law firms during the S&L crisis still operated as partnerships. Some of these partnerships had 1,000 lawyers in 50 different cities. Well, what happened is a partner in a Denver, Colorado office who had nothing to do with the S&L failure could still be held liable because one of his partners that he may have never even met in Chicago or New York did something that got the firm sued for malpractice. So when you're in a partnership, you're taking a significant risk, not only because of your own conduct, but because of the conduct of all of your other partners. Now, also, partners have something called joint and several liability, which means that if one partner does something negligent and has no assets to pay the judgment, the other partners have to pay it. I know one law firm here in town, when the savings and loan business melted away, they went from over 100 lawyers down to about 40, and each of the remaining lawyers had to pay about $400,000 to cover the malpractice of the partners that had advised a certain savings and loan. Okay, now the tax consequences to a partnership are pretty simple. Partnerships don't pay taxes. Instead, each partner in a partnership reports their share of the profits and losses on their own Schedule C that they file with their own income tax return, and they pay the whatever taxes they owe. Now, the rule with partners is that the way a partnership is managed is that each partner is the agent of all the other partners and has the full authority to bind that partnership. So if one partner makes an agreement, even if the other partners don't know about it, they're bound by it. Also, unless the partnership agreement says otherwise, each partner is entitled to an equal vote in any management decisions. Now, partners stand, with regard to each other, partners have a fiduciary duty to all of their other partners. Now, as part of a fiduciary relationship, which we've talked about before, I would just remind you that partners have, first, the duty of loyalty. What that means is that a partner has to put the interests of the partnership above their own interest. For example, if a business opportunity comes their way, they would have to present that opportunity to the partnership before doing it on their own. Another duty that partners owe is the duty of obedience. So when the partnership makes a decision, the partners have to go along with it. And they own a duty of care, which means that they have to act reasonably in their dealings with their other partners. Now, partnerships can own property. And the way that works is that each partner is a co-owner of any partnership property. Now, each partner has the right to use and possess any property owned by the partnership for their purposes. Now, when a partner dies, the interest in that property transfers to the surviving partner or partners rather than the estate of the deceased partner. What the estate gets is the value of the partner's interest in the partnership rather than the actual property. Now, this can be a big deal for estate planning because sometimes, and there's good reasons for why a partner might prefer to have the partnership property or their share of it go to their family rather than the other partners. And the value of the partnership interest may not adequately protect the family members. So that's an issue to consider. Now let's talk about the nature of partnership interest. If you own an interest in a partnership, then your interest is your personal property. What we get with with your partnership interest, you can sell it, you can transfer it to somebody else, and you can even use it as collateral on a loan. Now, your creditors could attach your interest in the partnership to collect your debts. However, when the interest in the partnership is transferred or pledged as collateral or attached by a creditor, that doesn't make that person a partner in the partnership. All they get is the ability to that partner's share of the money. Now also, if you're a partner and you transfer it, you're still on the hook for liabilities of the partnership to any existing creditors. Now, partnership interests are not all that easy to transfer. First of all, as a general rule and under the Uniform Partnership Act, which is the law in almost every state, in order to sell your interest in a partnership where the buyer can become a partner, you have to have the consent of the other partners. And so if they don't give that consent, that interest can't be sold. Now, how does a partnership dissolve? Well, the parties can agree to have their partnership dissolve, but they can also dissolve by operation of law. And in Colorado, when a partner dies, the partnership dissolves. If one of the partners in a partnership files for bankruptcy, it automatically dissolves. Or you can go to court to have the partnership dissolve. Now, if a partner in a partnership goes bankrupt, normally that means that the other partners will be following him to bankruptcy if they have not already done so, because all of the bankrupt person's assets are at risk, and as a partner, you have joint and several liability. So as a practical matter, what happens is the one partner takes bankruptcy, the creditors start to look to the other partners to get paid, and normally one partner, the remaining partners are either having to pick up the slack for the other partner or taking bankruptcy. So normally when a partner goes into bankruptcy, the other partners and the partnership goes into bankruptcy as well.